like firstly, we can say like the patent is a grant like for the invention which an individual made. uh, it's a grant by the government for an invention which an individual made for his invention, like his invention, in exchange for the full disclosure of the invention. Like in order to avail a patent grant, like one has to disclose the complete information to the uh, concerned authority, like patenting authority. He has to give a complete disclosure of his invention. Then only like the board, like this patenting authority, will check, like will go for the like searching, and then like a prior art, or whether it is like a traditional knowledge like is being available or not, like that will be considered, and then the patent will be granted basing on that like aspects. Then we can say that like patent is a grant for an invention by the government to the inventor in exchange like of full disclosure of his or her invention. We can say that it is an exclusive right. It is an exclusive right granted by the law to the applicants or assignees, like in order to make use of their invention or exploit their invention for a particular period of time. And also, apart from that, like the patent holder also like get some certain legal rights, like to exclude others from commercially exploiting like his invention for that particular duration of the time. In return for that, in return like for those exclusive rights which he is aware, the applicant is also like obliged to disclose the invention to the public. Like he has to give the like details of the invention to the public, which will like which enables others or else like in that area like skilled in the art, or to replicate the invention like in future period of time, like after the limitation of like after the limitation period for the grant of the patent. The present patent system is designed in order to like balance the interests of the applicants or assignees, like those who has the rights, and as well as the interests of the society also, like basing on this disclosure of the invention, like it is balancing the rights of the individuals, like the society, as well as the individuals who has been granted with the patent right. The present like patent system is being is like has been designed in that way, we can say like that. Also we can go in depth like regarding these aspects. But firstly, it's a kind of like basic introduction. There are like four major types of patents. One is like standard patent. It is kind of like ordinary patent, where we can see in all other countries. Generally what the patent is being awarded, like it's a kind of standard patent or ordinary patent, where we can see in like all other countries, like. And a patent of edition, like if some kind of improvement or modification for an invention, like which one has been awarded or filed like for the grant of patent. If for for that invention, like if some improvement or modification has been done, like then he can also like apply for the patent of edition. He can also apply for the patent of edition. uh, this patent of edition like remains in force only like for the period of time, like where the original invention like has been filed. From the date of filing, what is the like duration for the duration is given, the same, like the same until then, like it remains in force as long as the patent for the original invention remains in force. And then utility model patents, like we can see, like only in some countries like we can see these kind of inventions, like Australia, China, Japan, like only in some kind of, like in India it is not like existing. These kind of like patents were not being awarded, only in some kind of like kinds of some toys, like or else household goods, uh, for the kind of like devices like which we can see in day-to-day life, like for the utility model patents, like those are being granted. Here those are not in existence. And plant patents recently, like previously those were not being granted, and after the introduction of like this PPVFR Act, plant protection and plant protection of plant varieties and farmers rights act, like in the year of 2002, like after the introduction of that particular act, even like plant patents are being granted in our country also. And coming to the aspect of like uh, international like scope of the patent, there is no particular form of like old patent. You have to like remember this concept, like there is no particular form of like world patent, which is like the term is like so popular, but you shouldn't like uh, go into that kind of policy that like a world patent is exist. Generally if someone wants to get like patent for his invention in a particular country, he has to apply in all the countries, like where like he feels like the particular invention is being exploited like commercially. He has to file in that all the countries, like in all the countries firstly, like but the if in particular if in India is filing, like he'll get the chance of like this priority date. The date of filing in India will be treated as a priority date, and that priority date can be utilized as a like claim in order to show that like he is the inventor, and then basing on this, like he may file on the other countries also within that particular like duration period of time. Like moreover, this priority date like of 12 months, not 12 months I guess, like 18 months, like is given, is like standard in all the countries. Once a patent has been like has been published in any one country in the world, like it becomes a prior art, and consequently it can be deemed to be in the public domain. And in all other countries where the patent application was not filed within the stipulated time, like which is like 12 months only, 12 months like from the date of filing the patent application in any country, for like convention application, like in other countries like applications, like if he wants to, or else like even PCT, like patent cooperation treaty, where like many of the countries are being members of this like particular treaty. Even that also like provides ease of convenience in filing, but it won't give the grant of patent in all the countries with a single application. We have to like keep this point in mind, that like whoever the person residing in country, like residing in a country where the patent has not been filed, can exploit the patent for commercial benefit in that particular country without any restrictions whatsoever, or without any obligations to the patent holder. One can exploit. one can exploit. So in order to avoid that, he has to firstly file the patent application, and then it will be published. It will be published in the domain for published in the domain, and then that can be treated as a priority date, and within that time 12 months is the limitation time where he can file in the other countries also by using this as a priority date. Even the kinds of uh, like uh, application, patent filing method, we will see in depth after while going on. As I mentioned, there is no single organization, there is no single organization in the world which grants patents that is valid across the, even though there are some rationalization efforts that have been taken up by various countries as well as organizations, even there are European Union, some kind of treaty, and unions are being formed, and those are confining to that particular reason only. When it comes to the European Union, the member countries, if you are filing in that particular union, that particular member countries only will protect your patent. And when it comes to other union, the uh, Asian countries, or else African countries, or else American countries, in those countries it can be exploited. Only the particular union countries, union members, that particular countries, it will be given protection. That's what is the thing, that's what is the scenario in real. But the patent cooperation treaty, it is permitting of filing a application which covers major members, major members in the globe, and also it initially avoids the necessity of multiplicity of uh, pardon. Multiplicity of filing different patent applications, which even reduces the cost of patenting. It reduces the cost of patenting. By reducing the cost of patenting, it provides uh, burden to us. It gives relief. It gives relief. Moreover, we can say that. However, by applying for the PCT application, it will serve for the purpose of obtaining a priority date, and then also it facilitates international search with regard to novelty, inventive step, and industrial applicability by giving an opportunity to the applicant, like uh, in all these aspects. It will make an international search, and it will see whether it can be patentable or not. Firstly, we have to keep in mind that in order to be patented, the may three co- uh, 3 points we need to remember. If some invention which uh, may be patented, it should contain novelty. Novelty means new. These concepts, for the entire patenting aspect, these three concepts should be kept in mind: novelty, inventive step, and industrial applicability. Are you getting me? So, uh,
Yes, sir.
yeah, yeah. If you have any doubt, like just feel free and ask. Like, it should be like interactive session. That's it. Then only you will get. That's what.
Yes, sir.
Yeah. Yeah. These three concepts should be like kept in mind, like novelty, inventive step, and then industrial uh, applicability or industrial uses. Like you can say. As like section 2 clause I of the patent act 1970 like defines the term invention, like whether like invention, the like for an invention like which is to be granted, these three these three concepts are to be fulfilled. When it comes to the novelty, like it should be like new, which means that the invention has not been like publicly disclosed in any form or anywhere in the world. Only like this priority date of like 12 months, which is like common in all the countries, like this can be treated like whether he can like publicly expose in some exhibition, also like whatever the like proofs available that he has invented or like he has publicly disclosed, and within that like 12 months, like these 12 months can be given as an exemption for him, only for him, like by showing the relevant proof this 12 months of exemption will be given, and basing on that like the application will be treated into consideration whether it should be granted with patent or not. When it comes to the novelty, only this is the exemption, like 12 months period, like if it is, if it has been like displayed anywhere by him, or like or if it is like some organization, like by some of the person related to that organization, or if it is like group of persons who has invented or applied for the like patent, if someone has like disclosed the information like among the group of that particular inventors, like, someone has to done the thing, it should be within 12 months, then it can be considered. And then like after novelty, like this inventive step. After novelty, then like it's invention, like new inventive step, like the inventive step should not be obvious to someone like who is skilled in that particular field, in that particular field or whomsoever, like moreover we can say in that particular field whoever the person is so skilled in that particular field, it should not, the inventive step which is involved should not be obvious to, like suppose we can say that like when it comes to invention of some like kind of soap or some drug, you can say like medicine, goes to like say that like varying the composition of the substances, like just by varying the composition of the substances, like 2 is to 1 ratio of some substances leads to another kind of like medicine, which will give some effect like for some kind of like which will give some kind of relief for some kind of disease. It can be said like treated as an obvious thing, like it shouldn't be obvious, the invention shouldn't be obvious, like just by making some minor changes like this proportion, or else like just by combination of some other like existing chemicals or substances, like if you are making invention in such kind of step like which is easier or like which is obvious for some kind of like to a person who is like skilled in that particular field, it cannot be treated like it cannot be further like considered for granting of the patent. And then thirdly, like it should has like its industrial applicability, then only like a patent can be given. If it doesn't have any industrial applicability, like then it can't be given like a patent. It can't be granted with the patent. Then like it may be treated as like this what we can say like, industrial design. You can apply for industrial design instead of patent. There are other kinds of like various other forms of like IP rights which are applicable. We can see some other like, alternative in order to like protect our invention. That's it. Like in order to be awarded as a patent, like granted with the patent, these three should be fulfilled. That's what is the criteria. Along with that, like also we have to see like what things can be patented and what things cannot be patented. What things can be patented, like we have seen, like like as we said, like despite like it should be new and non-obvious, and then like industrial application should be like fulfilled. These are the like inventions which will qualify for the grant of patents. Apart from that, like section 3 of the patent act, section 3 of the patent act 1970 also says that like what are the inventions that can't be like patented, that cannot be patented, like frivolous inventions, you can say like uh, inventions which are like contrary to the established natural laws, like, you can say, which are like contrary to the established natural laws, like you can say like something which has been invented and it is like contrary to the well established principle, like some science principle, then it can't be like given or guaranteed with the patent. And also like which will cause like injury to the public health or like damage to the environment, even those can't be also given with the like this patent. And also the like invention which creates like contrary to the public order or morality, those are also like if the primary use of the invention is like majorly concerned towards like in creation of contrary nature against the public order or morality, or like if it is like affecting the health of human or animals or like plants and affecting the environment, and like uh, these like things can't be like granted with the patent. Or else like even discovery of any living thing or non-living thing, like living thing like non-living substance which are already present in the nature, like by saying that like I have found this thing, like this should be granted with the patent. Like I have found some stone like which is having some kind of like uh, which no one has identified. Somewhere I went, like I have found something, some stone like which has some kind of uses like I may found that like, but that can't be patented. It may be either living organism or non-living substance. Those can't be patented. Also the process of treatments like treatments for human beings or like animals, medicinal process like a surgical process, like the process of treatments also can't be like patented. Those are like patented, like obviously like the thing is that like in the society, if those treatment process also like has been patented, then only certain group of organizations or like hospitals will be permitted to do so, and are only limited, then the cost of uh, treatment will go high. However, only this kind of like process of treatment only, but the if some kind of machinery is existing, and for that machinery like, running process like that can be patent. However, for a kind of organization which has invented some mission for treatment of some kind of disease, that can be patented, but the entire process of treatment can't be patented. That is the difference like you should get it. Also there's a clear cut like exemption with regard to what we can say atomic energy operations, like when it comes to like mining, extraction, or like and atomic energy operations, like respect to these things, like Indian government strictly has a ban on the grant of this patents in this area, in this particular area, like there is a clear cut ban on this, like, and a method of agriculture or horticulture also can be patented, and inventions like products and processes which like which forces a country to do like atomic weapons or biological warfare weapons, like those are also like can't be patented, like explosive devices, like those kind of inventions can't be patented. Even the same with like agriculture methods or horticulture can't be patented. But the same thing like what I said with the treatment process, like when it comes to the method of agriculture process can't be patented, but a machinery which is being used for agriculture can be patented by its applicability and usability, like it can be patented, but the method of agriculture can't be patented. Are you getting my point, like what I am trying to say?
No, say, may you please clarify a little bit?
Okay, I was saying that like the process method of agriculture in the sense like the way we are doing like manually or something like that, like method of agriculture, like I'm trying to say the method of agriculture used to be like plowing the land and then seeding and all the kinds of activities involved are being involved, and by simple changing of some kind of pattern, if I'm making it to be patentable, like instead of seeding in some kind of form, I'm seeding in another kind of form, like by using some kind of, or else just for example I can say for curing the disease only, you can say for curing the disease in with respect to like treatment, I'm treating mm, treating like an individual, uh, like physically without using any kind of like equipment also like whatsoever, like I'm treating, the way of treatment given by me can't be patented. The way of treatment given by me can't be patented. But when we are using some machinery, like machinery which is already an invention by some kind of like by one individual or else like one organization, you can say, the machinery can be patented for his invention. The machinery which is used for like treatment or else like agricultural purpose can be patented, but the method which we are using can't be patented. By using that particular machinery, like we are using a particular form of method, like in the agriculture or else in the treatment, the method which we are using can't be patented, but the machinery which has been like made can be patented. Are you getting me right now?
Yes, sir.
Yeah, that's what is the thing, like actually like whatever may be the like process, like I'll explain you in brief. Like I'll explain you in brief. Like process patents are also being granted. Like along with the like for a kind of like particular invention. Along with the invention, even process patenting is also like existing. Like the process which we are using, like which has a usability, like with respect to like this machinery only. That process also can be patented along with its like entire machinery. The process which is being used can also be patented. I'll explain you in brief, like regarding that aspect, and all the other like formats like a mathematical or like computer program, such as algorithms, can be patented. However, in US, like these computer algorithms, like computer program, will be patented. But in particularly with respect to India, like section 2 class K, I guess, like section 2 class K, subsection 2, I guess, like of Copyright Act, which like protects the computer program, which protects the computer program as a copyright, but it can't be patented. When it comes to the like US laws, like the computer program is patentable, but in like in India it can't be patentable. Like even there is a like use like discussions are also going on with respect to like Internet of Things, IoTs, like which involves like a programming, but like IoTs can be patented subject to this particular clause only. Like IoTs can be patented, like as it involves a computer program which is a copyright item, and it is not subjected to be patented. Basing on this aspect, like these IoTs can be patentable in India as of now. A huge debate is also like going on this particular area, and also like whatever the other forms of like IP rights, like when it comes to literary, dramatic, or musical works, like those are subject to be like copyright. Those are subject to be granted with the copyright, and whatever the other forms of like IP rights available, those are not falling on under this like subject criteria of like patenting. These are the things like which can be patentable. You can say when you are going particularly with respect to like section 3 of this patent act, you can see like what is not an invention, whereas like section 1 clause J of the like patent act will says that like what comes under invention, and section 3 goes with like what is not an invention. That's what is the difference, like you should see. And like I said, like these are the basic elements of the patentability for an invention. Like it should be like novelty, industrially applicable, and it should be non-obvious. also like another uh, element like it is not like it's a kind of basic element I can say. It's an subsidiary element I can say, like it's kind of like first to file or first to ignore. This is another ground where like a patent application may be rejected in like some of the countries, not like particularly in India. Like in some of the countries, it can be like it's a ground of patent, like where it can be rejected. If someone has invented first, like he has to be the one who has to like file first by disclosing all the like uh, details of his invention. If someone knows the invention like already by him, or else like he has also been done, like he may like who comes first, like who files first, like shall be given preference. That's it. That's what is the simple ground. Like this, like we need to keep in mind in some particular countries only, like some the particular countries like US, Australia, and Canada, like those kind of countries like will follow this rule. And already like I have said, like as this like patent, the term of like patent is like will be for like 20 years from the date of filing of the applicant, like, uh, and then like subject to the payment of this renewal fee, it will be like it will be existing, and then like the expiration period will be prescribed on that aspect of like payment of the renewal fee and all, like. However, like it is to be noted that like the validity of patent is like not being guaranteed. There is no existing like patent system which guarantees like absolute validity of patent, like if it is like granted. Like the act also like provides for search among the records of patent offices, like based on the published material available with them. Like it can be really revoked at any point of time, like if some objections are being raised, like subsequently like it can be revoked, or else like if like basing on that inventiveness like or obviousness, like if someone is being like creating some obligation or like objection on that basis, like it can be subjected to be revoked at any point of time, like, or even like there are some remedies like which are available with respect to like legal remedies, like there may be imposed a temporary injunction or permanent injunction for some point of time, or like permanently like it can be given with injunction till the point of time like it has been like granted, like whether it is like obvious or non-obvious, or the invention is in the like subject of like section 2 clause 1 clause J, or else like section 3 of the patent act. Basing on that thing, like the tenure of the patent may vary. Usually it is for 20 years, may vary, like basing on that like circumstances. That's it. That's what is the thing. Also like there are like certain sections like which you need to remember, like basing on this kind of like the definition of like invention and non-invention, as well as like this uh, new like novelty. These things like you have to keep in mind, like these are the basic aspects like you have to keep in mind for the point of like examination, where you can elaborate these aspects. These are the basic aspects, these you can elaborate further. Like if you are going, we have to see the procedure for filing of a patent. Moreover, administration and then like procedure. That's what is the thing. As you know that already, like the Patent Act 1970 is the governing law with regard to like patent aspect, and it's been amended like the Patents Amendment Act in the year 2005, and even like patent rules like 2003 are also in existence. Like these are the certain guidelines which are being governed in the aspects of this patent regard. When it comes to the like administration of this like patent in India, like this patent system in India, it is being administered under the superintendence of Controller General of Patents, Designs, Trademarks, and Geographical Indications. A Controller General will be appointed like in order to look into the aspects of like patents, designs, trademarks, and geographical indications. Even this Controller General is the authority to grant patent or like trademark or else like industrial design. He is a granting authority firstly with respect to like our India. The Office of Controller General functions like under the Department of Industrial Policy, Promotion, and Ministry of Commerce and Industry. Under the Ministry of Commerce and Industry, the Office of Controller General like will function. There are like four patent offices in India. The head office is located in Kolkata, and the regional offices like are in Delhi, Mumbai, and Chennai. You should like just for the sake of information, I'm telling you like, these are the this is the administrative body which is being governed. Also, the controller general delegates his powers to like senior joint controller, joint controllers, deputy controller, and assistant controllers, and also for the examiners of like patents. In each of the office like to discharge their duties according to the direction of the controllers. In each of the like branch offices, like he will delegate his powers like to all of these people. Even I will tell you the hierarchy of these offices in the patent office. Apart from this, like there is a patent information system which is located at like Nagpur, which is functioning as a patent information base for the users. This patent information system of this, like in short, like PIS, like they'll be termed, will maintain a comprehensive collection of the patent specification and patent related literature on a worldwide basis, and like also provides this technological information contained in the patent or patent related literature through its search services and patent copy supply services like to the various users in the like in the fields of like this research and development establishments like government offices like or private industries business whatsoever, like whoever may be in requirement of these like data with regarding to like patent database. This is the this is the information system which is located at or based at Nagpur, is providing the information and being functioning as the information base with regard to like our country. Also, like when it comes to the hierarchy of like officers like in the patent office, like the controller general of like patent or designs and trademark and GA will be the higher authority, and then senior joint controller of patents, then like joint controller, and then deputy, and then assistant controller, and is like it comes to the examiners of patents and designs. This is the hierarchy to be followed like in the office of patent. And like the jurisdiction of like patents office in India is like whoever like an applicant of first mentioned applicants in case of like joint applicants, it should be like the first mentioned applicant, or in case of like single applicant, he'll be the one like can file an application for patent at the appropriate patent office, like under whose jurisdiction he normally resides, like wherever he resides or being domiciled, like, subject to that jurisdiction, he has to file the application with regard to like that patent office. Even territorial jurisdiction also like exists for the branch offices and head offices. Basing on that aspect, like one has to file the application basing on that jurisdiction. Also, there exists like kinds of patent application. It should be like ordinary application and application for patent of edition, as I said, like, and also like divisional application. Kinds of patent I said, like, related model or like standard patent and patent of edition. Those I have. This kinds of patent application will also be like existing according to its uses. Like, should be like it is ordinary application, application for patent of edition, like which I said like earlier for either for improvement or modification of the already patented invention. For that kind of invention, any application for patent edition also can be applied. And divisional application in case of like plurality of inventions, like the like plurality of inventions like has been mentioned in the main application, then divisional application is to be filed like in order to explain in brief about a particular kind of like invention which you wanted. Like two inventions are being mentioned, a divisional application can be filed for like uh, complete information, like for subject to kind of one particular invention. And also like convention application is like what we can say is that convention application is like in different countries, like where we have to file by basing on this like priority date, by for filing the like for claiming the priority date, this convention application is to be filed in different countries. Like in particular like convention where which we are the member, like in that convention members, like we have to file this convention application for claiming the priority date of the invention. And then also like national phase application under this PCT. After like this convention application, we have to file our national phase application under this PCT. This is the types of patent applications which are like in existence. Also, who can apply? Like that is the major question, like which is to be answered. Like the inventor, like obviously has the right for application of the patent, either alone or else like jointly with another. Like if the invention is like subject like, made with like a group of people, either he alone can do it or jointly can make an application. Even he can assign our legal representative, like, can also like uh, can do that, like in case he is not being available, he can assign someone like for the application process, or else in case like the inventor has deceased, like is assigning, or else like legal representative of the deceased inventor, like can also like apply for the patent. Going to the aspect of like uh, this like procedure for filing of a patent, which is like the major aspect which we have to deal with. Just a minute. Like going to the part of like procedure for filing a patent in India, like there are various steps involved in the filing, examination as well as like its acceptance of like complete specifications or provisional specifications, and then the step of like granting of patent will be involved, and these are to be like briefly explained. For filing of the application, as I stated like earlier, like who are the persons like can file and where is the jurisdiction, like basing on that like aspect, one can one should like be ready for the filing of the application. Basing on that like jurisdiction aspect, territorial jurisdiction aspect, and the person who has to be filed by paying the like prescribed like by filling the prescribed application and the prescribed pro forma, like which accompanied by the fees and along with its like provisional or complete specifications. Like the aspect of provisional or complete specifications is like I'm saying it's like kind of giving the invention detail of the invention, like it should contain the drawing of the invention, like if it is like kind of process, it should contain the drawing, uh, also like what are the steps involved, like what are the steps involved, like if in case like the priority of invention exists, like what is the priority and everything, like the conceptual stage, like whatever may be the thing, the complete description of the invention, along with it like the patent application, the complete description of the invention should be mentioned along with the like this specifications, whether it is provisional or complete in the sense like it should be like in the complete specification, the title of the invention, field of the invention, background of the invention and object, as well as statement of the invention and summary of invention, along with a brief description with the diagram, also like detailed description should be mentioned with the reference to the diagrams also, and then claims, abstract, these are all to be mentioned in the complete specification. Whereas like for the sake of like you may file like one can file either with the complete specifications or provisional specifications, or initial filing of the application. For initial filing of the application should be like complete or provisional. If one is like going with like provisional specifications, like then complete specifications to be filed within like 12 months from the date of filing of the provisional specification. That's what is the only criteria which should be kept in. Like if complete specifications are not being like mentioned in the application, one has to go with provisional specification filing. Along with that, like in 12 months, like within the stipulated time of 12 months, one should give with the complete specification of the invention. That's it. That's what is the major like one should keep in. Just in order to file the application, this is the criteria. The filing involves like either filing with provisional specifications or filing with complete specifications. If provisional is being filed after within 12 months, like complete specifications to be filed, and the complete specifications will involve these aspects of this title of invention, field of invention, and background of invention, and then objective of the invention, statement of invention, and summary of invention, brief description along with its diagram, and detailed description of the invention with reference to that diagram, as well as claims of that particular invention, what he wanted to take with that invention, what he wants to like, what is the applicability or usability of the invention, and then abstract. These are thing like it's to be given, and within this like application of filing, there are like certain key codes which we have to keep in mind. There are like that like I'll provide you in the next class, or else like in the next class I'll provide you the material like, for that like key codes, as well as like I had some PPTs like, that I'll provide you for the like fee and all, like the criteria of fees and everything were mentioned in that aspect, as well as like the complete procedure of this like PCT filing are also being like mentioned, that I'll provide you later point of time. After the filing, like after the filing of this complete or provisional specification, like after provisional specification we have to go with like complete specification as well. Like after this particular filing, uh, the along with the required documents and like fees, the patent office like will give an application number and give you the like filing date, give you the filing date to the application immediately after filing, which is like it should be like identified with the series along with the year of like such filing. After that, like no application like basing on the concern of the priority matter, and in order to like keep the invention disclosed for a period of like 18 months from the date of filing of the application, no application will be open for the public. At the end of this 18 months period, like the application like basing on the this application, after the expiry of like this 18 months period, the application will be published in the official journal of that particular like patent office. With respect to like our India, like our patent journal will like publish, and then like basing on that, like after the publication they'll receive like generally like the objections regarding the invention, like if something like that, like if someone has any like objections regarding the invention, they'll receive it. If not, like they will proceed for the examination of patent application. Even this publication also like will be given with the number of like application, the date of filing, as well as like with the title of invention, whatever may be like the file which we have given, like whether we have given any like patent of edition or divisional application along with that, like as well as if PCT application is being filed, even along with that application number and date, or also like number of pages, abstract, everything like will be like given along with this like publication. if like any objections are being raised, like if any objections has been like given, one point I wanted to share in this regard. The point is that like from the date of like publication of the like, not publication of the application, uh, the date of filing of the application, like the person has been entitled with some kind of rights, except for the infringement. Like he can oppose any of the right which he will obtain, like for the grant of patent from the date of filing of the application itself. Like one will attain the rights except for the infringement of the patent until it has been granted. Like previously, like before January 2005, like before 2005 amendment, it used to be like even like the previous applications used to have that rights also, like but after that amendment, like except for the infringement right, except for the infringement, like he can claim any of the right, like which uh, shall like come into force like from the date of filing for the grant of patents, for the rights which have been awarded with the grant of patents, like he shall be conferred with all the rights except for the infringement. Only the infringement like he can file after the complete grant of the application. That will take time. Like the grant of patent will take time, like from the date of filing. That will take time, like for this will be for like 18 months, like for the priority date. Like the disclosure of information will be for 18 months, and then from here, like this examination of patent application will be done like within 12 months, and the report is to be submitted. And then after the examination, like this grant of application will be given, like this grant of application will be given based on that criteria. Also, like if you want to mention, like you can mention the required documents for filing a patent application. If you want to mention that application form in duplicate, like application form in duplicate, as well as like provisional or complete specification. If provisional, like it must be followed by the complete specification within 12 months, like and drawing if necessary, like drawing also, like if it is a kind of like machinery kind of like the process, the drawing also should be added. The abstract of the invention and information and undertaking listing the number, like filing date and current status of each foreign patent application. If he has like filed other like application also, like those like country application numbers also like to be included here. If not, like it may be omitted, but if he has been filed like within in any other countries also, that also can be added, and the status regarding the same, like at that particular period of time. Those are the applications. Along with that, like priority document, if like priority date is to be claimed in any convention application, a priority date like priority document can be obtained. And also the declaration of inventorship, where provisional specification is followed by complete specification. If provisional specification is being applied, like, then complete specification, like this declaration of inventorship, along with that, like it should be applicated only in case of like convention or PCT application fees. In other countries, if he is applying in other countries, this is also to be added. And power of attorney, like for the case of like generally this power of attorney is like taken in these circumstances only, like in order to assign someone. This power of attorney is being given. This power of attorney, if like filed through patent agent or like assignee or someone like legal hair, legal hair in the case of only death only. Like if it is assignee or like patent agent, like this power of attorney is to be added. And then like fee in the form of like check or like DD. This is to be. These are the major documents, like major documents which are necessary during the patent application filing. These are the things. After this, like filing and publication. After this filing of the application, like, and publication of the application, this examination will be conducted. Like actually, even for the examination also, the applicant or any other person like have to request for the examination. Like within like 48 months, like within 48 months from the date of priority or from the date of filing. Like, he has to like make an application. If not, like even that will be treated as it withdrawn application. If not, like it can be considered as like there is no conduct of any examination is required. And further, like he don't want, he is not interested in like obtaining a patent. Like it may be treated as withdrawn, and further it won't be proceeded with. For examination of patent, like within 48 months. After this 18 months period of time, like it will remain like that. Like after the publication, if any objections are being raised, it will be with the controller. It will be with the controller. The objections are to be raised. If not, like it will remain like constant. And within 48 months, like one has to request for the conduct of examination of his patent application, his or her patent application. If not, it will be treated as withdrawn. Even for these like patent examination, like application examination, prescribed fee is to be paid, and then a request is to be made to the like controller, and then he allots the like application to the examiner, who will examine the application and submits the report to the controller, who in turn like communicates all the objections as first examination report also, like, to the applicant. Whether if any like in case like if some objections are being raised, like some objections are being raised without even any examination, like they'll inform. But like if not any objections, like he has to for sure like apply for the like request for the examination. And then like the examiner, like the examiner, after the examination, like he'll submit the first examination report. First examination report, that like even every application like will be examined in two stages, like formal examination, which like shall be comprising with the scrutinizing of like or checking, in order to ensure that all required documents and fees are like filed in conformity with the provisions of the patent act. Like the first is like will involve only with regard to like the ensuring of the documents, like prescribed documents handed over and an external. This is the formal examination. Like in the first stage, like it is to be given. And the second stage is like technical examination. Like according to the provisions of like section 12 and 13, like it will assess like whether it qualifies the basic requirements of patentability of like this novelty, obviousness, like industrial applicability. These are all the aspects like they will exam. Like this is the second stage, which is like technical examination. This is the technical examination, and after this like phase, like even the objections, like the objections can be taken till the time of like 12 months from the date of issue of like this first examination. The objections will be taken and will be heard before the controller. Before the controller, these are to be heard. Like and then like both the parties, like not only one party, like the controller will issue like notice to after receiving an objection, like to the applicant also, like will receive a notice, like both the parties are being heard at the same point of time before the controller regarding the objections. Like one can claim based on the like his relevant objects regarding his patentability. That's it. And if there are any objections, like it will be put like a petition can be filed and it will be appealed in front of the appellate court. Previously, like with respect to IPAB also in the syllabus, like intellectual property rights appellate board, like intellectual property appellate board exists. Used to be uh, in existence like till 2021 April 4th. Like from then, it was like seized. It was seized. With respect to trademarks and these patents, a separate like appellant board has been constituted. And the year like 2021, like 4th April, like it was like seized. In the year like 2007, according to the section 23 of like Trademarks Act 1999, according to the section 83 of like Trademark Act 1999, this was like constituted, like intellectual property appellate board was constituted by taking members like one technical member who is like well versed with in this area, like who used to be a controller formerly like was taken as a technical member, and chairman and vice chairman will be of like retired judges like of high court level. Those are like constituted, and the deputy registrar also like used to be constituted as a board, and then IPAB like was formed everywhere like along with that like IPAB was constituted from the year like 2007, according to section 83 of like the Trademark Act. This was constituted in 2007 after April, I guess. After April, it was constituted. From the April 2021, it was like seized. It was no more in existence. For the examination in being, like you may just go through once. You may just go through once. After the things are being heard, like if any objections are being raised, like the objections will straight away go to the controller general. Like firstly, after the like this like thing is being published like in the journal, the objections will go to like him along with the first examination report also, like the examiner also like will take the objections to the controller. If anything is to be appealed, it will straight away used to go to the uh, IPAB. Firstly you usually like formerly it used to go to IPAB, but right now the jurisdiction exists at district court, and then like the appeal may go to like further the appeal may go to high court. The matters regarding like the patent issues, the jurisdiction rests with the district court, and then like basing on the value of the matter, like it may go to high court. That's it. That is the ultimate like the jurisdiction like which will deal with the patent regards. Moreover, like even the cases won't be even go to the Supreme Court also. Like recently, one case went to the Supreme Court, but still it was like being reverted to Delhi High Court. The state concerned, like whichever may be the state, the district court is the jurisdiction for regarding this infringement and all. And even like the point to be remembered is that like IPAB won't have the uh, right to like listen with regard to infringement among like all other cases, like all other appeals, like IPAB used to hear, but with regard to infringement it's completely the discretion of the district court, and then like it's high court. And right now there is no even like doubtfulness of regarding the jurisdiction. There is no IPAB board which is being constituted as of in existence. Straight away like goes to the district court and then high court. That's it. From controller general, it will go to there. After this, like examination of this patent application, this provisional grant of the application, the controller will grant the patent and issue the letters patent as soon as possible after the applicant has met with all official requirements within the like specified period of 12 months. Like in these 12 months, like if no objections are being raised, like then immediately the provisional grant of the application will be issued like by the controller. That in case like no opposition or any other like opposition is being like represented and disposed of like in favor of the applicant. And after this like provisional grant of the application, like the renewal fee to be deposited, and then for keeping the patent in force, like for keeping the patent in force for the particular desired period, term of the patent, like the renewal fee are to be like paid, and then like it will go on, it will go on until like if some objections are being raised, like even after granting of the provisional applicant also, like the uh, like oppositions can be taken. Still, the oppositions can be taken before the grant of patent as well as after the grant of patent. After the like before granting the patent, like section 25 clause 1 deal with this matter regarding like oppositions against before granting of the patent. Like whereas oppositions against patent after granting of it, like deals under like section 25 clause 2. 25 clause 2 deals with like after grant of patent opposition, and section 25 clause 1 deals with the before grant of the patent of application. Thus like you may go through once, like even that's what is the thing, like these are the major aspects like which are to be known. That's it. Mm, just a minute, like I'll show you a diagram. uh, I'll just share my screen, like you can see the diagram.
Say I can see your
Yeah, right now
screen.
can you see, like just in the material only it was given. Right now can you see?
Yes,
Yeah,
sir.
like this is the like
Yes, I can see, sir. Yeah.
yeah, yeah, this is like the procedure for grant of patent. Like firstly the thing goes with like can you see the cursor, like I'll move the cursor, like filing of application with provisional specifications. If like with provisional specifications, like complete specification, if it is like not filed within the duration of like 12 months, it will be abandoned. Like if we are going with provisional specifications, like then complete specification is to be filed, then like a request for examination is to be done. Like even straight away we can go with like complete specification. 18 months like publication is being like after 18 months like publication is also like being done. Then we have to request for examination, and then first examination like report will be given, and then if any like amended documents are required, like they will let us know. Like the primary stage like of the application like examination will be regarding the list of documents submitted and the prescribed. If not, like they'll return it, and kindly like we have to submit the amended documents, and then they'll re-exam. And if any further objections are being like heard, like like if objections are being like complained, like it should be like heard by controllers. And if all objections are being like complained, if all objections are like being complained, like then the patent will be granted same way. This is the this flow chart like which is like kind of clear, I guess. After 18 months of application, if like pre-grant opposition is like being heard, then they'll allow or reject the thing, like after publication. It's like if it is like if any amended documents are being heard, then re-examination is to be done. Then like if objections are being heard, this is the criteria. If objections are not being heard, or like heard and complied with like all the objections, like it is like everything is satisfactory, then grant is like given. If objections are not compliant within 12 months, like, then it will be abandoned. Like, it will be abandoned. This IPAB, like if like objections are refused under like section 15, like then it used to be appealed to IPAB, and right now like this IPAB is not in existence. Like this, you can omit it. Like this IPAB, this will be like substituted with like a district court or else high court. This is the thing for the entire grant of like patent. This is the thing in general. Like, when it comes to like patent filing application in other countries, like actually the thing is that like I stated earlier, like beginning of the class, like Spain, like no organization or no other country like is providing for the single application like granting of patent overall the world. In order to avail the patent grant in the entire globe, there is no single organization which is like providing us. The option left with us is like to file a separate patent application in each of the country, that like wherever he feels like it, the invention like the invention made by him like will be commercially exploited. Like there is high chance of like commercial exploitation. In order to like protect his invention over there, like he may like see the circumstances basing on his invention like and the marketability over there. Basing on that, like he has to file the invention. And like within the filing of like firstly like he'll file within our country, like in this country, and then like then he may go by basing on this priority date like claim. He can show the same priority date claim of application in our country as a proof over there, and he can apply over there within 12 months like of filing of the Indian patent application. This is the one option like which is being available. And the other option is like the PCT, patent cooperation treaty application. Like as I stated, like instead of like filing separate applications in each of the selected countries, like that have potential for the invention, a single PCT application can be filed like within the prescribed manner. Like it shall be filed as like priority for grant of patents will be given, like will be obtained like in the overall members of the PCT. A single application can be filed, and, and the designation designated countries like will like have its protection, will give its protection like different phase of like this application. It will like moreover like it will moreover give like simultaneous protection with a single application with reduced cost, and like even like he'll gain much time also. Instead of filing in different applications, like he'll gain time, he'll gain much time, and moreover like he will save much of amount also. On an average, like if he wants to file like the application, like the fee like paid like the fee for pay patent application, like for grant of patent application, it's like almost uh, will be 5 lakhs to like 7 lakhs around, like for four countries, like four developed countries. It's UK, US, China, and then like in India, it will almost take almost 5 to 7 lakhs in order to like protect his like invention, in order to protect his invention by applying for patent in every country. Instead, this single PCT application like will give his like will take this burden out like, by giving like simultaneous protection and reduced cost and gain of time, like, by gaining of time. A single PCT application will give much ease of like convenience, you can say. So, the PCT application filing like I'll show you first. The font is in white color actually, which it is in Word document. Like you can't see that thing. I will later edit it and then I can show you the PPT regarding like PCT application filing only. The entire procedure is being like uh, described over there. regarding that PPTs, like tomorrow I can show you. Like I edited them. I- I'll edit them and I can show you tomorrow. This is the major thing, like in brief, like regarding the filing of the application. Then the steps involved with respect to like international filing and national filing. With respect to international filing, I didn't explain in brief like that. I'll go with like tomorrow. I'll go with in brief. Uh, but today, like we'll conclude the topic with respect to here only, like with respect to here, and tomorrow we can further go. If you had any like concerns and doubts regarding this, like you can ask. Hello. If you had any doubts, you can ask. Just feel free to ask regarding to this, like
Currently, no doubts, sir.
yeah,
Yes.
then fine. Regarding
Sir,
this, yeah, yeah. Tell me.
sir, but then I wanted to ask about our assignment.
Yeah,
Um,
that only I will explain you that only right now for next for this class. Like I will tell you that only. The thing is that like
okay,
you
sir.
have to uh, if it is in writing, you have to make two copies in writing. I'll advise you to go with like word format of assignments. Like moreover, like December that like May 30 is the final date, I guess, like, for the assignment submission. You have to start right now.
Sir, may you please come again?
Like May 30th is the last date for assignment submission, I guess. Like
Sir.
you have to submit, like you have to start right now. Your assignment work, with regard to your assignment work, you have to start right.
Okay.
The thing
And
is that
then, where can I get the assignment?
like actually you have to start, like you have to start, you won't be getting anything like uh, are you being provided with any material? Have you been provided with the material like regarding?
Uh, yeah, on the website.
Yeah, even on the website also
On the website.
even on the website, like you can get like project handbook which will disclose like entirely. Even that I'll explain, no issues regarding that. Like, you have to choose, just take a screenshot of this, like I'll share the ppt, like I'll share the screen. Just take a screenshot of this. These are the themes. These are the themes. Can you see the screen?
Yes, sir. Now I can
Yeah,
see it.
yeah. These are the themes actually. Like you have to choose any two of the components, like either drafting and filing a provisional patent application, or opposing a patent application, like after grant, is like post grant opposition of obviousness, like are opposing a patent application on the grounds of like prior art.
Sir, this is for the assignment?
Yeah, for the assignment actually. Like I can help you out in this
Okay.
regard, like it's fine. uh, you have to take any of the two components like which are listed in the B column. Like eight components are listed. Out of these eight components, like you have to choose any two.
Yes, sir.
Any two, and you have to like uh, make a format of like patent application along with that like thing.
Okay. And one more question is this supposed to be handwritten or we can type it out?
That's what I am saying. Like if it is handwritten, two copies like are to be made. One is to be preserved by you, and one you need to submit. If it is like handwritten, it will be difficult to write twice.
Yes.
If it is handwritten, it is difficult to write voice. So that's why like it is advisable to make it like typed, like in our format. Like you can do it, and you can make this. You can make this like as a PDF, and you can share it. Like you can forward it the same. That is advisable. But you should be well versed with this thing. Like the thing is
To
that like
whom do I submit the assignment?
it should go to like it should go to like this address, New Delhi, like university. You should make two copies, and one copy should be sent to this particular address. Just take the snap of this thing, or else like further you can contact me. To this particular address. Like you should send the thing, as well as like by supervisor. Like firstly, you should make a proposal. Actually, you should make a proposal on what aspects like you want to do your research, and you have to like get approval from your supervisor. Moreover, I think like I'll be your supervisor for the
Sir, can
project
you please
assignment, or
say the
else like you can
steps
even.
slowly? Sorry, may you please say the steps
Yeah,
slowly
okay,
because I'm very, very new to this and I know nothing.
okay, 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 fine. The thing is that like firstly you have to make a proposal for the research which you want to do. Like I have shown you like the themes. Na, I have shown you the themes, like on what areas you wanted to. Firstly, are you getting me? Like
So, sir, this assignment is different from the project because we also have a
this
project
is the
in the
same.
curriculum.
This is the project only, like I'm saying.
Okay, so
This is the
there's a
project only,
project.
like uh
Also, there are no like little assignments because I was at the not
no, no,
regional
no.
center, yeah, at our regional center, and some people were submitting like little assignments they were getting. So I thought maybe we had. So if we just have a project, that's all.
Just tomorrow, like just wait, like I need to consult with sir. Project is like compulsory, which you need to. Like regarding assignment, like your course curriculum, I have to see like once. For every single subject, like for three papers, three assignments are required. Like, are you asking that point? Like,
Yes, sir.
just a minute. Sir, sir, are you there, sir? No one. Like, I'll come back to you like for tomorrow. Like, but like, leave about the assignment. Like, firstly, moreover, I'm not sure about that assignment. Like, if assignment is there, that is handwritten. For sure, like that is handwritten. One copy you need to send to like regional center. But leave about that assignment like
So
essay.
when I'm sending this assignment, I have to actually go to a post office. I have to go to a post office and then send it to that address.
Like to the regional center address only. Like assignment should be sent to the regional center in Visakhapatnam. Like through post you can do it. Whereas like this project need to be submitted like to the university campus directly. This project is to be submitted to the university campus only. I had this proforma like proposal proforma. Like you need to firstly like choose themes like out of this. Hello, are you getting me? Or is it like too
Yes,
different?
I understand about the assignment. I'm just not understanding about how to send this. So I have to write the proposal
No, no.
first and then I send
Leave,
it
leave,
to.
leave, leave about the assignment. Like for today. Like I'll confirm you about the assignment tomorrow. But this project is mandatory.
Yes, and
This
this
project is mandatory.
project, for this project, I have to actually write a proposal and then send it to the
Yeah,
school. It's
to
like
the
a
school
letter.
firstly. Yeah, kind of like a letter only. It should be of like minimum of 4,000 to 500 words. Like it should be minimum of 4,000 to 500 words. And that should contain even I had like the proposal should contain like on what themes like you want to propose and how you are intended to go about it and what are the objectives of your study. Like that you need to make it.
Okay, sir. So I have to do it right now, right? Because
Yeah, you have to start it there is no much time. Like if you are when is your examination, like when will be your examination? It will be in June.
my exam is in June.
If it is in June, by December 30th, like May 30th, I need you have to send it to the university campus, I guess. It's better, like
No,
it's
no.
advisable to
December.
not December,
By
May,
December
May,
I'll be
May.
out of the country.
Okay. Not December, I'm saying, like
So
by
that's
May,
why
May,
I
May
want to
30th.
just do everything, and I just want to write my exam in by the June exam, and
Okay,
that's
okay,
it.
okay. Then May 30th is the last date, I guess. Like May 30th is the last date. Make sure that you start with the proposal early and I'll be the supervisor. Moreover, that you just confirm with the director sir, like once, or assistant director sir, deputy director sir, once. Like I'll be the supervisor, and they'll let you know like regarding my contact details also, like regarding this thing. You can contact me, and I have to just sign a this thing for your supervision. Like I have to sign an approval for your proposal, and then you have to send the same to this address, this particular address. You have to send your proposal firstly, and then don't wait for the confirmation of the proposal. Just start your work basing on that proposal. I'll guide you, no issues regarding that. I'll guide you regarding that, no issues. Just uh, just contact the directors or assistant directors
Okay,
once,
sir.
and take the details of mine. You can ask the details of mine, and then you can see, you can go with regarding course, your this thing, this supervisor, like project supervisor, who is the project supervisor. Just ask them or confirm with them, like either it may be the Ramanamurthy sir who previously taught. Moreover, I feel like I'll be the one who is handling with this thing. I'll be the one, if it is him, just contact with him, or else if it is me, just try to contact with me. I'll help you out. Previously already,
Yes,
we had
sir.
two students, previously two students, I dealt with the same course, previous batch. On two aspects, you have to do in Word document. Just take a screenshot of these topics, these themes. It is advisable. Just see.
Yes, sir. I've done that.
Okay. Then this is the address. Just take a screenshot of this same. This is where the project is to be submitted. Then I had an access where this declaration and copies also, I can even edit it and help you out in this thing. This is the address where you have to send your proposal. That's it. Take a screenshot of this also. It will be helpful for you. And tomorrow in detail, I'll tell you about the PCT application based filing.
Sir, sir,
Yeah, yeah. Tell me.
I have
Yeah.
another question. It's the It's
Yeah,
saying that ensure that your proposal is accompanied by a letter of approval by your supervisor, which means
yeah,
that you have to send me a letter of approval, right?
yeah. Yes, yes, yes. Like I can scan you and I can send you the same you can attach like
Yeah.
in the PDF format. Like the same you can attach. Like I'll
Okay.
just sign
So
it and I'll scan it.
can
I'll
I have your email?
yeah, fine. Like will you note it down?
May you kindly like type it in the chat box? Hello, sir.
Just a minute.
Sir, can you hear me?
I can hear you. Can hello?
I can hardly hear you. May you write the email address in the chat box, please?
Yeah, yeah, yeah. Right now, right now, can you hear me? Yes. Right now, can you hear me? Like my network is like gone. Like that's there is some disturbance.
Yes, I can hear you, sir.
Yeah, yeah. Yes. Yes. Yeah. This is my email ID. Like I have sent you in chat box. Yes. Hello. Can you see the?
Yes, sir.
Yeah, yeah. Okay. That's what is the thing. Like that's the thing. Over. Hmm. Yeah. This is the thing. Like just consult with this, Risha sir once like director sir, and then like you can get back to me. Like moreover, I'll be the supervisor. I don't know. I'm not sure. That's it. Like, just confirm with them, and then you can approach. It's fine. Like I can even help you out if
Yes,
even Ramamurthy sir is also like your coordinator. I can help you out. Just, firstly, just check
yes,
with
sir.
this like topics. I'll suggest you to like tomorrow. Further, you will go in depth. Like we'll go in depth tomorrow, and like as like I have taken like very few classes, I can't go in depth regarding every subject, like every point. That's what is the thing. Further, like I can help you out even in this regard. Uh, you can see like previous existing cases. There are some cases like regarding prior art and all. There are some cases like which are just basing on those cases, I feel like defend a patent granted on grounds of prior art, like this will be easier for you.
Okay,
This
sir.
sixth theme, like sixth theme will be easier for you, like as there are many cases like regarding prior art and all, like that will be easier. And then draft and file a provisional patent application, that will be somewhat tricky. And
Sir, it
oppose a
is saying
patent
that
application.
some of the themes some of the themes that you can choose from are given at the end of the handbook. Um, can I see
These
that
are the only
handbook there?
themes. These are the only themes. Like these are the only themes. No other. These are the only themes. Like these are like examples. Like these are like application formats and all. Like everything was explained in detail. Like only these are the themes. Like I have already been dealt with. Like only these are the themes available, which you can do on your like work. These are the things.
Okay, is it possible that you can also send me this document, sir? That just that so that I
Yeah,
can just go through it?
yeah. You can mail me. Like I'll revert back to you. It's fine. Huh?
Okay.
I'll share you even other material is there like with me. Like I'll forward the same to you. It's fine. You can just mail me so that like I can get back to you. It's fine. That will be fine. Like if you had any doubts, just feel free and like ask me. Like if it is more
Yes,
interactive
sir.
session, like you will get the knowledge. Like that's it. Like that's what is my thing. Like even I will be in that kind of thing only. If you had any like doubts, like tomorrow, we'll go with this PCT filing procedure, as well as this uh, opposition, post grant opposition and pre grant opposition. I didn't dealt like in detail. If you want, like tomorrow, I can go in detail. Like, that's it. Like regarding the this thing also, like we can go in detail, like project also. Hmm? That's what is the thing like for today. Tomorrow we can see. That's what is the thing. Like you can mail me. I'll share you the documents. That's it. Okay, then can we end up the session for today?
Yes, sir. And I have already sent you an email. I hope you will see it. It's from Isabel01,
Okay, okay,
Isabel01.com.
okay. Just yeah. I got it. I'll revert back to you. Huh?
Oh, okay, sir. Thank you very much.
Yeah. Okay then. Bye then. For today, this is the session. Like tomorrow, just if you had any like further doubts on this regard, for today's session, you can let me know. Like tomorrow, I will come up with like those things also. If you had any doubts.
No, no doubt, sir. Thank you very much.
Yeah. Yeah. Fine, fine, fine. Okay then. Like
You have
bye
a
for
good day.
today. Like tomorrow. Yeah. You can leave.